Member for Oakville Gordon Head.
Thank you, Honourable Chair. I have one section now. Through no fault of my own, in my university days, I did not go into the field of law, although I did want to. So I don't understand a lot of the legal context of this. So I'm going to ask a question that perhaps the Minister could expand upon with respect to this requirement for policy. Now, there's been some very disturbing incidents at a number of post-secondary institutions, and both of these, in these cases at different institutions, the same problem arose. What the problem is that there were incidents of sexualized violence in student dormitories. The university's response in two separate universities was to attempt to evict the students involved in as the perpetrators, and in both universities' cases, there were claims that lawyers were arguing that if you evict my client, we will sue accordingly. So my question to the Minister, through you, Honourable Chair, is: do we need to have changes to the Rental Tenancy Act at some point to deal with these type of issues, or could the policies within the universities under the present legal framework allow them to have policies that would evict students were they to be found not guilty, but found to be in violation of the Sexual Violence and Misconduct Act policy at a particular institution?
Minister.
Thank you, Mr. Chair. And for reasons that are historical happenstance, rather than to address this particular issue, the Residential Tenancy Act does not apply to student residences. Now, that is a rather tepid answer to the important question that the member raises. And so, once again, the Act is designed to address and encompass a number of proscribed activities. The location is irrelevant, and that is anticipated, that is contemplated to be irrelevant. And so, if it happens in an apartment off campus or in a residence on campus, or as I said, in a field trip to Costa Rica, the Act will still apply. When the involved individuals return to the campus, they will be subject to the university policy, which will largely be related to protection of the interests of the victim in terms of health and safety, and what I will call separation rather than segregation from the alleged perpetrator, so that the mental health and well-being of the victim can be protected in a safe environment. That may contemplate changes in the residential status of an individual. One can contemplate a very small institution with residential facilities. There are a few in this province, and that would then be incumbent upon the institution within its policy to provide for academic accommodation to protect the interests of the victim. One can contemplate that that could require the perpetrator to be removed from the residential facility, and perhaps even removed from the campus if it's a close, tight-knit campus, so that the victim is no longer exposed to daily contact, visual or otherwise, with the alleged perpetrator. And so the episodes the member refers to, I believe, happen in other jurisdictions, and our law contemplates this scenario inadvertently through the Residential Tenancy Act not applying to university residences. Nonetheless, the point the member makes is if an alleged perpetrator engages legal counsel and threatens or implies or sends demand letters, that must be contemplated by the institutions that will be captured by this Act. They must be prepared to deal with that. They are not to be timid in the face of an alleged perpetrator who's retained counsel. That would essentially defeat the purpose of the Act.